In our society, when things go truly sideways, when something bad is happening, we're expected to put our trust in the police, to have confidence in them to uphold justice, law, and order. But what happens when a police officer makes a terrible mistake, or when a cop is simply not up to the high standards that we require? Today we'll be talking about when law enforcement breaks the law and policing the police. Hello and welcome to Talks on Law. I'm Joel Cohen. Joining us today remotely, we have the woman who actually wrote the book on police law. Rachel Harmon is a law professor at UVA. Rachel, welcome to Talks on Law.
Thank you. Thanks for having me.
And I mentioned in the intro, you've recently written on this topic, and it's not a skinny novel, is it?
No, it isn't. It's about 950 pages.
Why don't we start with the challenge? I mean, police officers have enormous power, enormous ability to do good, to help save our lives and protect our families and homes. But with that power, they also have the ability to abuse it. What is so challenging about regulating police in this country?
I mean, if you think about the police as one institution that we use to try to generate public safety and public order, especially when we need to do so forcibly or when we think we need to do so forcibly. But we don't always need to put hands on bodies, and we don't always need to make arrests or do the other course of activities that police do. And in some ways, that's the real challenge of policing, deciding when the state's commands need that kind of enforcement, when they don't. And because of the authority to do that kind of thing, there's a lot of opportunity to be unfair, to be corrupt, to be abusive, as well as to do the things that we hope to achieve with using police.
Professor, one of the reasons why we're having this conversation, and I suspect one of the reasons why you wrote your book, is the incredible scrutiny or the light that is shining on police because of horrific abuses that have come to light in recent times and the perceived oppression of minority groups. Is this something that's new in America?
It isn't new. It's true that there's a lot of attention right now to problems of policing, and especially the ways in which police contribute to racial oppression and racial injustice. But that is not a new problem in policing. Almost as soon as departments were created in this country in the mid-1800s, there was concern about the way that departments were treating African Americans and immigrants and the racism that policing contributed it to. So there's no question that that problem is not new. There are cycles in policing in which we pay attention or don't pay attention to the problems, but the communities that suffer most at the hands of the police have always been aware of these problems. If anything, now more of America is seeing some of the problems in policing firsthand through video recordings of the police.
It seems like quite a challenge when you create a group that's there to enforce the laws, and then how do you regulate that group? Do you have to create a separate police for the police?
It depends how you think about it. The police are not magical creatures. They don't simply exist. We create the police through law. If we didn't create the police through law, if we didn't authorize what the police do, then what the police did would be crimes. When the police arrest you, it would be kidnapping. When they use force against you, it would be assault. We allow policing through the law. We make exceptions to existing laws for the police, and that means we govern the police. This is not, so the question of whether we can police the police, the question is really how effectively we're going to govern these people we're giving authority to and what authority we should be giving them.
Why don't we take a quick look at the regulatory framework, I suppose, in place, at the laws in place that enable us to police the police. At some level, the Constitution is always at play. So maybe we could talk about, you could give us a quick overview on that, as well as what other legal avenues we as a society have for regulating the police.
If you ask most lawyers or law students or actually police officers, what is the law that governs the police? They're going to cite the Fourth and Fifth Amendment. The Fourth Amendment, prohibitions against unreasonable seizure, and the Fifth Amendment, as interpreted by Miranda, which regulates interrogations. Those are important. So in particular, the Fourth Amendment, which governs arrests, it governs searches and surveillance. It also governs the use of force. When we think about a lot of the problems in policing, when we talk about criminal prosecutions of the police, when we talk about civil damages actions against the police, we're often talking about arguing that they violated constitutional rights and with respect to the Fourth Amendment. Not always, but often. Of course, that's not the only law governing the police, but it is really, really important law. And we enforce it in a variety of ways. We have the exclusionary rule, we have criminal prosecutions, we have damages actions, we have suits against police departments. And when people talk about policing the police, they're often talking about how rigorous that constitutional law is and how effective those remedies are. But beyond all that, there's the state law that authorizes what police do and state remedies that help address policing when it goes awry, and local governance of the police. Most policing is local, and it's governed by municipalities, which fund it and hire and fire chiefs and decide what the police department should be doing in the community.
And in your analysis, is the state and local, is that where the rubber is actually meeting the road?
Often, yes. So, for years, we've focused so much in academia and also in popular culture on the constitutional law and constitutional remedies that we didn't pay enough attention to the way that localities and states were actually governing the police, were authorizing police behavior. That's really shifted. If you look over the last couple of years, there's this new attention to the role that states play in regulating the police and how communities could choose anew how they want to make public safety, considering civilianizing some aspects of policing or looking to other actors to do some of the things that police now do.
One of the areas that's, if not the area that's garnered the most criticism of the police is their use of force. You mentioned how the police are necessary or helpful when we need something actually done or when we need hands laid on people. But it's that very power, when misapplied, that can be so horrific. Why don't we talk about the restrictions constitutionally first on police use of force? Are there any?
The Fourth Amendment prohibits unreasonable searches and seizures, and the use of force is a seizure under the Fourth Amendment. So when police officers use force against somebody, they must comply with the reasonable seizure requirement.
That's a conversation about probable cause and reasonable suspicion?
Probable cause and warrants, or an exception to the warrant requirement, is how we measure reasonableness when we're talking about searches or other activities like arrests. But when we're talking about the manner in which the seizure is carried out, we don't go to probable cause and warrants, because that doesn't make any sense. We have to ask, well, how do we know if the manner that the police officer is doing this legitimate activity is legitimate? And to answer that question, we go to the base requirement of reasonableness. And the Supreme Court tells us, or tells lower courts, to balance the interests of the government against the intrusion on the individual in deciding what's reasonable. But in establishing that balance, they've been pretty generous to the government.
Yeah, that sounds pretty vague. It sounds to me like use your judgment.
Well, it's use your judgment and then have courts assess what you've done using their judgment. Courts aren't supposed to exercise 20/20 vision. They're supposed to recognize that police make decisions under changing circumstances, that they have a difficult job. So what constitutes reasonable use of force in the Supreme Court's case law, which considers whether somebody is resisting or fleeing or threatening the officer or others, that reasonableness analysis allows police to use especially a lot of non-deadly force. In the deadly force context, the court is a little more restrictive. You can't use deadly force against a threat that is not of serious bodily harm or death, or against somebody who is fleeing just a non-dangerous crime.
Well, yeah, why don't we talk about those separately? So how about use of non-lethal force? You know, I'm fortunate enough not to have been violently arrested, but I watch plenty of TV. When you see an arrest and the person is slapped in handcuffs and slammed against the wall, you know, is that reasonable? It seems unnecessary to slam the person against the wall. Is that a cause of action there?
Not usually. Under federal case law, a lot of circuits would call that de minimis force and would say that there is no constitutional violation there, even if it's not necessary. The courts don't use necessity as the measure of reasonableness, or at least not the minimum force necessary as a measure of reasonableness. And that is one reason why a lot of low level, right now we're very focused on deadly force, and with good reason, but non-deadly force is far, far more common. It injures many, many people, and it is far less thoroughly regulated. The case law is pretty permissive with respect to non-deadly force. Certainly uses of weapons. So if you start to get into tasers against passive resistance, then the courts get a little bit more aggressive. But in terms of that kind of regular, old, unnecessary, harmful, and alienating force, you're not going to get a lot of a remedy in the Fourth Amendment.
Prior to your current law professorship, you worked in the Justice Department, and while there in the Civil Rights Division, am I right?
Yeah, I prosecuted federal civil rights crimes in the criminal section of the Civil Rights Division.
And did you have to deal with cases involving, excessive force or police assault or police abuse?
Yes, in federal law in particular. So the federal criminal civil rights statute has a very high intent requirement. It's willfulness. You'll often see it talked about in the media because it makes it difficult to bring federal civil rights charges against officers. But it does permit the federal government to intervene to prosecute local, state, federal police officers who intentionally use too much force against an arrestee. So I said, throwing someone up against a car might not count, but kicking a handcuffed suspect once he's under control, that certainly would be excessive force, and it would be prosecutable by the federal government.
It just seems really problematic to me that the definition is so loose, and that the law seems to allow for a certain amount of roughhousing by the police.
Yeah, so the less force that's involved, the more permissive courts are or the more resistant courts are to policing the line. They don't want to get in the business of second guessing every slap and punch. And that means that the Fourth Amendment is not an effective check. It's one of the reasons why we should be looking elsewhere to regulate that kind of force. I mean, just because the Fourth Amendment permits it doesn't mean communities have to allow it. It doesn't mean states have to authorize it. And it doesn't mean that we have to accept it as a standard part of policing. I think that for so long, we looked to constitutional law to remedy the problems in policing that we forget that the fact that the Constitution permits something doesn't mean that we have to allow it.
And how about with deadly force? You mentioned the courts. I mean, the law here is the most restrictive, and courts will take a more critical look. Yet it's still very challenging. It has been very challenging to successfully bring claims against police for deadly force. Maybe let's start with the test. When can police officers use deadly force?
Police officers can generally use deadly force in two circumstances. The most common is when they feel they are threatened with a use of force or a threat of force that would cause serious bodily harm or death. It could be that they're threatened. It could be that another person is threatened. And the other is when someone's fleeing a dangerous crime, when someone has engaged in a crime of violence and are fleeing, and the only way to subdue them is to use deadly force against them.
You can shoot someone for running away from a crime?
Police officers don't always use force in the circumstances. And not every state permits the full range of force allowed under the Supreme Court case law. But under a case, Tennessee versus Garner, the court said you cannot shoot a non-dangerous fleeing felon in the back of the head, but you can shoot a dangerous fleeing felon in the back of the head. And what makes somebody dangerous in the court's view is the circumstance in which the person is threatening or using serious force against an officer or another person, and therefore is actively dangerous in the moment. But the Supreme Court suggests that there's another form of dangerousness, which is being suspected of a violent crime. And according to the Supreme Court's case law, you could shoot that person as they run away.
If you're chasing down a suspect who's accused of a terrible crime, let's say a violent rape, but has never seen his day in court, it may in fact be the wrong person. In an arrest, if that person flees, a police officer is constitutionally justified to use deadly force against the fleeing suspect?
It would appear so under Tennessee versus Garner. Police departments cringe, police officers and communities cringe in the same way that you're cringing. If you think about, one of the big checks on the use of force, community sentiment matters too. Police departments face the court of public opinion probably more often than they face federal courts bringing constitutional cases. And so those kinds of uses of force are certainly conflict with many people's gut reaction about when we should be using force. And as a result, you see usually when officers use deadly force, the claim is that they believed that they or someone else was threatened. And usually it's that the officer himself faced a threat of serious bodily harm or death.
Let me also get on the record. We're going to be talking about police abuse, and we're going to be talking about failures in policing and the system that's in place to hold bad policing accountable. That's in no way to suggest that all police officers are bad, or that police as a group don't do so many important and critical things to keep us safe. So I just want to get that on the record. But we will be asking tough questions, and I know that you have done some real tough thinking on it, from both the academic side and when you had spent your days in justice actually pursuing crimes.
One thing I would say about that is, despite the fact that I spent many years as a prosecutor, including on policing cases, I actually think that criminal prosecution is not the best way. It's sometimes important because there's a respect that criminal prosecution shows for the victims as equal citizens that I think it can be critical, but I don't think prosecution is the best way to handle most problems in policing. And I think focusing on the individual wrongdoer or the individual actor in policing is often a mistake. Policing is about systems. It's about the choices we make in terms of authorizing a behavior, but it's also the choices we make in structuring police departments, in tasking them with certain activities. And the problems we get are usually a result of institutions, not a result of bad people.
Another area where police can play a very intrusive role in a citizen's life is just by making an arrest. What is constraining the officer from making excessive arrests, or from bringing people in, disrupting, intervening, stopping their life, even if it's just for a few hours, without justification?
The constitutional law requires that there be probable cause before an arrest, and probable cause is just an amount of individualized suspicion, an amount of evidence we need to have that you committed a crime before the officer is permitted to arrest you. But that's not a very high barrier, and most states allow officers to use the discretion to arrest when they meet that standard and require a little more. In most cases, you're not required to have a warrant to make an arrest. And if there's no probable cause, they could be sued for a wrongful arrest. But the bigger issue in policing is to me at least, is why make so many arrests at all? Even if we have probable cause that you committed some crime, and there are a lot of crimes, that why does that mean we need to take you into custody? Because as you point out, the costs of engaging in an arrest are really substantial to the individual, who might lose their job if they spend a night in jail, and it certainly might be traumatized by that experience and won't be home to take care of their kids. And there might be immigration consequences, and there might be housing consequences. And so this is very disruptive. It's disruptive to the family. It's disruptive to communities, and especially in communities that are over policed, and in communities that have a sense they're being discriminated against. Then any arrest, even a justifiable arrest, is going to be further alienating. And so even lawful arrests can be seriously problematic. And one of the things that I've focused on in my work is asking questions about the costs of policing, even when it's legal, and encouraging communities and lawmakers to think about restricting activities that are more harmful and more unfair than the value that they bring to the table.
Let's talk about how police handle our vigorous, and when I say our, I mean American citizens, vigorous use of their First Amendment. I wanted to move the conversation into a discussion of resistance or a discussion of protest. Let's talk about that.
One of my favorite chapters in my new book, The Law of the Police, is on policing resistance. And I'm trying to bring together here the First Amendment law in the way that it regulates several different kinds of criticism of the police. Because one of the things that is interesting about police officers is that they get to regulate opposition to them. So when, a bystander comes in and starts criticizing the police for making an arrest, sometimes it's the arrestee's mom who's saying, don't arrest him, or trying to get in the way of that arrest. It's the police officer who gets to decide, at least in the first instance, whether that mom is going to get arrested as well, or whether her behavior is protected. And then courts later will tell us whether they made the right call. And, similarly in the protest environment, people protest many different things, but when they protest the police, then we've got this special layer of interest at stake, which is they're protesting the very people who are now deciding how thoroughly their First Amendment rights are going to get exercised. And the same thing's true when we're talking about recording the police. It's police officers who decide, at least in the first instance, whether recording is too close to the line. So courts tell us what the rules are in those contexts, but I'm very interested in the project of policing resistance and resisting the police in turn.
Well, I think you've given us a great roadmap for the next, 15 minutes or so. Why don't we take them one at a time? Why don't we start with the example of one person being arrested and then others in their community or in their family raising their voice in opposition to that? How does the court view the ability for individuals to speak up or to protest what might be seen as an unlawful arrest?
The Supreme Court has made it clear that purely verbal resistance or purely verbal opposition to the police is protected First Amendment speech. Police officers may never arrest someone for purely verbal opposition, and communities which used to criminalize any kind of opposition or interference with arrests, even purely verbal, can't do so consistent with the First Amendment. And so we know that's protected. And by contrast, the Supreme Court has said that arresting somebody who interferes with an arrest is not impermissible under the First Amendment, which then raises the question about what is the line between opposition, verbal opposition, and interference. If somebody is standing across the street Well, presumably that and shouting at the police officer, that's presumably verbal opposition. What if they're standing 10 feet away? What about 6 feet away? What about right behind an officer while he's trying to conduct an arrest? And the courts have found those questions far more challenging. Police are sometimes quite aggressive about people who are only verbally opposing them. And sometimes they just break the First Amendment law and arrest people for, what we'll call contempt of cop, which is simply being disrespectful or criticizing the police. But when even within the scope of the law, there's a difficulty at assessing what the line is between interference and criticism.
Yeah, that's very interesting. And when you say interfere, the first thing that came to my mind would be, maybe a desperate family member physically interfering. No, please don't take him or her, or trying to pull them away. But can interference be simply verbal? Can interference be, as you mentioned, maybe standing in the wrong place?
Well, it's not entirely clear. The Supreme Court has suggested that it's at least possible that some kinds of words basically function like acts. So imagine somebody is shouting in a police officer's ear as he is trying to question a suspect. Is that verbal criticism, or is that interference? Those are the kinds of cases that have been a little bit bedeviling. And then the same is true of verbal criticism that happens at a close distance, not because it's loud, but because the police officer feels threatened by being surrounded by a crowd, for example, or even just having someone stand in between them and somebody they're trying to question or arrest. And so there is no clear line. In fact, the case law is pretty messy in these areas because it's something that we really don't have a good standards for.
You mentioned it, but what is contempt of cop, or what is a contempt of cop arrest?
That's not a legal term. That's what we generally call casually arrests that are made because somebody disrespects or criticizes the police. There are dozens and dozens of federal cases that involve somebody giving the finger to a police officer and getting arrested. Now, every police officer knows that that's protected speech. That's not a lawful arrest, but you'll sometimes hear cops say casually, I can't give him a rap, but I can give him a ride, which is to say, I know this is not an arrest that will hold up because it's not illegal to give the finger to the police. But that kind of disrespect is something that some police officers in some departments are pretty intolerant of. And so contempt of cop is what we call a use of force or an arrest that is really retaliatory for criticism or disrespect.
Isn't that illegal? Isn't that a crime in and of itself?
Yes. No, good cops don't say that. That's illegal. Retaliating against someone for exercising First Amendment rights is itself a violation of the First Amendment.
Is there anything that you can say to a police officer that would rise to the level of something that would be arrest worthy? And I don't know whether I'm confusing my First Amendment limitations, but do fighting words apply to police officers? Is there something that you could just, well, that's just too darn offensive. Of course he's going to stop you.
So that's a really good question. That's actually an open question under Supreme Court case law. The Supreme Court has clearly suggested that if there are fighting words, the standard with respect to police officers, the kind of opposition that police officers should expect, verbal opposition and criticism, is greater than what an average person should expect. And they should be trained and prepared to face that kind of criticism for executing the state's authority. But what the court has never said is whether that means there are no words that would constitute fighting words against the police. And the lower courts haven't really clarified that issue either. There's certainly a lot of cases that suggest that it's not even clear whether there are fighting words that anyone should respond to.
Defending one's honor if certain words are spoken.
Yeah. Being called a bastard is not what it used to be. Yes, there's no question about that. So police officers are expected to have a higher threshold for that, but we don't know if that means there's no threshold at which they should exercise their power for purely verbal reasons. But if you ask me, I think they should not exercise an arrest, or certainly not a use of force would be inevitably illegal, but an arrest for purely verbal opposition, no, not okay. And no community should accept it. I mean, and most departments would consider that against policy, even if it's not against the law.
Are there examples of arrests going the other way for the officers who committed the contempt of cop? We're using these terms loosely. Have police officers been held accountable for that type of abuse?
So usually when we're talking about an illegal arrest, it's very, very rare for a police officer to be prosecuted for conducting an illegal arrest, if that's what you were talking about in terms of accountability. There are civil damages actions against officers for retaliatory arrests under the First Amendment, but about 2 years ago, in 2019, the Supreme Court decided a case, Nieves versus Bartlett, in which it said, although an officer having probable cause is not an absolute bar to retaliatory arrest claims, if an officer does have probable cause to make an arrest, then the courts are very, very skeptical of that the officer's motive was retaliatory. And since officers almost always can find probable cause to make some arrest, that doctrine, which requires that retaliatory arrest claims generally be for arrests that are on which there's no probable cause, is a real barrier to holding officers accountable in civil damages actions.
I'm just envisioning the police stop for a minor traffic violation. Okay, maybe I did roll that stop. It may be breaking an actual law. And then if I behave rudely to the police officer or in a way that he or she perceives as rude, maybe they could then retaliate with pretty good cover.
Yes, the Supreme Court has one narrow exception, which is if similarly situated people are not arrested for that offense, and here the court's thinking about something like jaywalking, where almost no one is arrested for jaywalking, then an arrest might be permissibly looked at as retaliatory. But in the situation you gave, where police officers occasionally make arrests for traffic offenses, but often do not, then it's going to be very hard to hold them accountable. And you're exactly right. The research supports the idea that police officers use more force and conduct more arrests against suspects who are disrespectful to them, or who they perceive as disrespectful. And of course, individuals are more disrespectful to the police if they distrust the police and they believe that the police are unfair to them or their communities. And so you've got this problem in which we're permitting something that, a kind of tension that the police actually are in part responsible for.
Why don't we talk about protests of the police? This is a pretty awkward position to put the police in. Go out and make sure that these people are safely protesting you.
One of the things about, I think, policing protests is that we think of the First Amendment as the main source of our right to protest. And certainly it does provide a right to speak. That's what free speech is, and that includes political protests. But protests are subject, like other First Amendment activities, to reasonable time, place, and manner restrictions. And under that guise, the police have a lot of discretion about how to manage political protests. So that's one problem, which is the First Amendment actually doesn't get us that far. It doesn't allow the full range of activities that we might consider worth protecting.
How do you mean?
For example, a reasonable time, place, and manner restriction could mean that an unpermitted protest that briefly blocks a highway or blocks a street, it result in mass arrests. It could mean that small amounts of property damage or violence in a crowd lead everyone in the crowd to be effectively treated as lawbreakers. The First Amendment permits governments ahead of time to set a reasonable time, place, and manner restrictions on protests, but also permits police in real time to decide a lot of how thoroughly people will be allowed to protest. And so a lot of the law of a lot of the rights to protest is decided actually not in courts, but on the street.
You raised a couple of really interesting examples, one related to this time, place, and manner provision. I'm envisioning maybe I have the right to stand on the sidewalk with 3 or 4 friends and talk about how bad the policing is. Yet if 200 more people join in and start clogging the sidewalk or the street, then the police may be authorized to break up that peaceful protest.
Within the scope of the First Amendment offers some protection, to be sure, but within the scope of the First Amendment, departments take very different approaches to disorder or to protests that interfere, cause congestion, block traffic, involve small amounts of property damage. Some departments are focused on facilitating free speech rights. They see that as part of law enforcement because, of course, the First Amendment is a law that the police are tasked with enforcing, which means protecting free speech, not just protecting non-protesters or protecting property from free speechers. And so, one issue is whether the police see that as part of their role. In departments where they embrace protecting the First Amendment, you see a very, very different attitude towards low-level disruption that results from protest, much more permissive attitude. And this is partly driven by community sentiment. Communities that value free speech and value political protest will and can demand that their police departments treat that as part of their mission, which is facilitating free speech.
All of this is really fascinating. Some of it is incredibly troubling. And for the legal mind, it can also be a little bit of a puzzle where you're trying to understand how these conflicting ideals work themselves out. One area that you mentioned was in a crowd. I'm there peacefully protesting. Let's say it's an environmental protest, and I'm saying, let's stop climate change. And next to me is, 20 other people saying, yeah, we should stop climate change. And then 3 or 4 people in the back are throwing rocks through people's windows. Why am I allowed to be tarnished with the same brush as those people who are actually breaking the law just because they're standing near me?
Yeah, that's actually a complicated one. We think of constitutional rights are individual rights. In fact, the Constitution's pretty resistant to respecting group rights. And yet that's clearly a context in which we are permitting an intrusion on one individual's rights in order to solve a problem that's created by another individual. I mean, this also comes up in the use of force context. So if the police use tear gas against a crowd because of a couple of people's activities, well, everyone in that crowd is being subject to a police use of force. We might want to think differently about regulating uses of force or dispersal orders that interfere with many people's rights. And sometimes we do, and sometimes we don't think very carefully about those distinctions.
So is it a question of practicality that the commanding officer is making a decision on necessity? And, when there's certain scale, individual treatment is just not a luxury that they can deal with?
Well, every state has either a riot law or a dispersal law or an unlawful assembly law, and sometimes all of the above, that permits police to decide that a crowd has reached a certain level of violence or disruption, and then make orders to disperse the crowd. And at that point, so long as they provide notice to the people in the crowd and an opportunity for people to comply with the order, then they conduct arrests to enforce the unlawful assembly order, for example. That ends the protest. That is a full stop to the exercise of First Amendment rights. But it's something that police use frequently to break up crowds.
So the two of the requirements, and I don't know, correct me if there are more, but one is a clear notice. And does everyone have to have been able to hear that notice? And then the ample time to exit, what does that mean in terms of minutes? Is it 5 minutes or is it 15 minutes?
This is a problematic area. And again, there are no hard lines, and the courts are sort of permissive here. But what we're talking about is, there's the triggering conditions before the officers are permitted to issue an order, because the order itself is a restriction on free speech. And then there's what are the conditions that have to exist before the police can enforce that order. And I mentioned two, which is there has to be notice. And that usually does not mean actual notice. It doesn't mean that every person in the crowd heard the order, but it also means that if a police officer just says to his friend, "Hey, you think it's time?" and then goes, "Hey guys, get out of here," he can't then arrest 1,000 people who wouldn't have had the opportunity, any possibility of hearing that order. So, courts struggle with what actually constitutes sufficient notice to the crowd. But if you get arrested because you can't quite get out of there, because, for example, other people are refusing to leave, then have you received fair notice and an opportunity to depart, or no?
It seems a very clear no.
In deciding whether those arrests are lawful, right? You might and remember, there are different questions here. There's did you commit a crime by violating the unlawful order? But then there's a separate question of, did the police conduct an illegal arrest when they arrested you for doing so? So you might have a defense, which is to say, I had no way out of there. But does that also mean that the police officer should be civilly liable, or the department should be civilly liable for conducting that arrest?
And practically speaking, does that entitle you to anything?
Not never. And in this summer's events and in the protests after Michael Brown's death in Ferguson, you did see courts get concerned enough to issue some preliminary injunctions requiring police departments that were facing repeated protests to be more careful about notice and the opportunity to depart following a dispersal order. But that's still an area where courts are not extremely restrictive. As in many areas, waiting to let these things get sorted out in court is often an ineffectual strategy. I mean, we really need more front-end rules for how we want police to handle these things, because at the back end, after they've done it, courts are really reluctant to sort of second-guess police who are making hard decisions in the moment. But police will, if told you cannot conduct arrests under the following circumstances, largely won't do so.
Professor, one of the ways that these police abuses have come to light is through the videotaping of police. Why don't we talk about the laws surrounding that? Threshold question: do we have a constitutional right to video the police?
Almost every court that has addressed this question has said that we do. The Supreme Court has not heard any of these cases yet, but every circuit court and most of the state Supreme Courts that have addressed the question have said, yes, there is a First Amendment right to video record the police activities when they're conducted in public.
There's some difference between recording and interfering. How would you draw that line?
Like other First Amendment activities, recording the police is subject to reasonable time, place, and manner restrictions. And courts are now struggling. So for a decade, there was this litigation about whether video recording was a First Amendment right. Now, the cases are turning to the question of, well, what kind of restrictions are reasonable, time, place, and manner restrictions on video recording the police? So just like we talked about interfering with the police, or, a bystander getting in the face of the police when they're conducting an arrest, if a citizen with a video camera walks right up to an officer who's conducting an arrest, is within a few feet of that officer, is that now protected First Amendment activity, or is that something that police officers can order them back and conduct an arrest if they fail to follow that order? And we still are working on that in the courts. I mean, the courts haven't yet decided what constitutes interfering with the police such that it would be, you can restrict that First Amendment activity.
Why don't we work our way in from bystanders to people actually involved, starting with the bystanders. I mean, how many videos have you seen where the officer says, "Excuse me, sir, turn off your camera," or "Excuse me, sir, put away your camera"? What is that?
There are a lot of those. I mean, this has been a right that's developing over time, but the technology has outstripped the law, and the law has outstripped the legal training that police officers have received. And so you will often see police resisting, less so now, but resisting being videotaped by either ordering people to stand back or by telling them to put away their cameras. And there are times when, we might be concerned about videotaping activities, even those activities in public. So for example, if you can imagine a homicide scene where the victim's family has not yet been notified, should we allow private individuals to record a picture of the body and post it to Instagram before the family is notified? That's a tough question. The First Amendment would protect video recording. That's not necessarily interfering with the carrying out of the law enforcement duties, but some courts might consider it a reasonable time, place, and manner restriction to forbid that activity. I'm not suggesting that that's the vast majority of the cases in which police are stopping people from recording the police, but I do want to say that it can be at least at times a complicated question. Overwhelmingly, though, people should be permitted to record police activities in public, and increasingly police recognize this, but for a long time they didn't, and you saw this resistance.
How about if it's an ongoing investigation and there's something that's somehow confidential? I could certainly imagine an officer not wanting it to be public knowledge that something is happening, or perhaps believing that they might have a leg up in their investigation if something did not become public knowledge. Is that good enough to tell someone to put away their camera?
I haven't seen a lot of those cases yet. We see a lot of those questions with respect to police video recording, which is when are police required to record and when can they turn off their cameras in places where they are required to make recordings, or when may they record and when they may not record, because sometimes recording by a police officer, just like by a citizen, can be extremely intrusive. Imagine a victim of a sexual assault who wants to report that assault but doesn't want to be recorded doing so. The same thing's true that issue is raised both by public recordings and by police recordings. I haven't seen a lot of cases involving the former yet. We are seeing statutes which are addressing the latter.
How about with relation to a minor? I mean, the courts do treat minors differently in many respects. When there's a victim, they're not identified by name. Does that carry over somehow into the ability to record? Let's say the victim of a crime happens to be a minor. Would that give grounds to tell people to put away their cameras?
Well, remember that, when police officers are interacting with victims, they can do so. They can easily bar video cameras by going inside. So we're really talking about videotaping public police activities. And so a lot of these questions are handled by police themselves merely by moving the activities into private locations. One thing is, it's really important to remember how recent, and it's so universal right now that it is very difficult to remember how recent change this is in policing and in the world, right? The first iPhone comes about in 2006. And so this has been a very short period of time in which, for the first time in history, many members of the public can see many police activities, something that was just not accessible. And so we're much more aware now of some of the harms of policing that were largely invisible, except to the communities that suffered, especially communities of color. Other communities, especially well-off communities, are totally unaware. Their experience of policing is completely changed now by seeing some of what goes on outside of their usual view. And so not just the cameras themselves, but the technologies of distribution have been a dramatic change in public understanding of the police.
So powerful. It sounds to me like a lot of the flaws that we have in policing the police, perhaps, what's the expression that sunlight is the best
disinfected. Yeah.
So maybe a little more exposure will be helpful in cleaning up some of the nastier side of policing. I don't know. Have you looked at the data on that? Is there data to back that up?
So I didn't know if there's data to back that up yet, but we do know that the tremendous, attention. I mean, there are complicated things going on because there's both the video recording of police, there's the distribution technologies, which used to be, it's not just the iPhone, it's YouTube, and now social media. It used to be when George Holliday recorded the beating of Rodney King, he first went to the police department and offered the videotape to the police department. He had this big handheld camera he had just gotten, and the police department expressed no interest. So he went to the local news station and they took up the tape. And then once it was played on air, it got picked up by the national networks and 24-hour cable news, which had recently had less to do because the Gulf War had ended. And so the tape gets played again and again and again. And if it had happened 2 weeks earlier, while the Gulf War was still going on, we might never have seen as national news.
What an interesting point. Yeah.
It's not true today. Why? Because the media aren't the mediators. They don't control now whether you see a video or not. And similarly, protests do not, can be organized very quickly by social media. And so that we're both much more aware of what's going on in policing, and we can be much more responsive to it, both en masse and in terms of calling our, politicians. And so what we've seen is a radical increase in attention to policing and recently, and a legal response to that. State legislatures are much more engaged in the project of thinking about how to reform the police than they were even 5 years and definitely 10 years ago.
We've talked about videotaping the police who are engaged in an arrest of someone else. What about when you're at the center, when you're the star of this horrific show? Do you have the right then to say, officer, I want to turn on my recording device, or officer, I'd like to videotape this as I'm being arrested, to preserve my rights and to preserve what is actually transpiring?
There are two different questions there. One is what you have a First Amendment right to do, and the other is really, you might think of as a Fourth Amendment question, or a question of state law and arrests, which is what may police officers prohibit you from doing physically during the course of a stop or an arrest. And so a police officer stops you when you're in your car and says, put your hands on the steering wheel. And that's for officer safety, right? So they can see your hands and you couldn't reach for a weapon that the officer can't see. And courts consider that a reasonable exercise of police authority to protect the safety of an officer. If you think of that as a reasonable command, then somebody who says, no, I'm just reaching to start my iPhone is no different than someone who says, I'm just reaching for something else. Either way, the courts might be concerned about disallowing police officers from giving commands especially in the context of officer safety. Now, there are some empirical questions about whether officers are really at risk as much as they sometimes believe themselves to be. But assuming that you believe that police officers are at risk in these contexts, and courts certainly do, then they're likely not to treat the First Amendment right as overcoming the police authority to issue those kinds of commands.
What if the camera's already on? What if, before the police officer arrived, you put your driver's license on the dashboard and you turned on your phone, and then you put your hand on the steering wheel and you politely let the officer know, my driver's license is on the steering wheel and I'm recording the conversation. Can they then tell you to stop?
Yeah, so then I think it's purely a First Amendment question. And the answer, I would assume, and again, the case law is sort of thin on this for a variety of reasons, but the answer should be no. It is not a reasonable time, place, or manner restriction to prohibit somebody from recording their encounter with the police during that encounter if doing so does not interfere with the arrest or create a risk to the officer.
What's your instinct on what how police officers would treat that? Is that something that would prevalently be seen as controversial at this point? Or
it's a really mixed bag. For a long time, I sometimes would do trainings with police officers as the rise of video recording started. And I would tell police, this is a problem that kind of was sorting itself out much more in the streets than in the courts, because police officers were resisting being recorded, and then they would be recorded resisting being recorded. And so that, and you've seen those videos go viral too, right? And on one hand, those can be a little bit depressing because you say, wow, look at this officer resisting this person's not only arresting somebody, but then resisting our ability to make that arrest transparent. But when you see that video, that's also a check on officers engaging in that activity. And you see that some departments have faced some public scrutiny and community opposition for engaging in that behavior. I mean, I guess one of my takeaways is always, the law of the police, we should tweak it. We should make it better than it is. We should make both the rules that govern police activities, especially the state law rules, clearer and give more guidance on the front end to police officers. And we should have better remedies on the back end. But we should also recognize that a lot of the ways that the primary way we govern the police is not actually in court and using law. It's in communities deciding what kind of policing they want through the political process. And we should be very active about asserting our views about the costs and benefits of policing in that context.
One more detour in the police recording aspect of our conversation. How about police recordings? Let's say I'm the one being arrested, and in many police departments, there are body cameras. Do I have any right to see that body cam footage? Do I have any right, even if I'm being charged by the police, do I have any right to access that, perhaps for my defense, or perhaps if it's a relevant issue?
So this turns out to be almost exclusively a matter of state law, and states are very, very different in how they handle this issue. Every state has some form, some kind of sunshine or freedom of information law that allows some access to public records. But whether body camera footage is considered a public record to which the public has right to access is extremely variable. Some don't consider it a public record at all, but permit access under some circumstances. Some consider it a public record, but don't allow access. And some consider it a public record and allow a lot of access. And then the question is, who gets access and under what circumstances? There are times when that evidence is discoverable in a criminal case, but those are relatively limited, and they're usually, if it's exculpatory, then it would be Brady material, and the government would have to turn over that footage. But that's really only when somebody is prosecuted, and many arrests never result in criminal prosecutions, and certainly many arrests that result that involve excessive force, the charges are often dropped. And so we're not going to remedy that in criminal discovery. Then we have to think about other ways to make sure that people have access to that footage. And that's an issue with state law.
Why wouldn't it be just a matter of law? You know, as the defendant, I have a right to the evidence that the government has against me. How is the camera footage not evidence that the government has against me, especially if the arrest itself is at issue?
Well, you actually don't in criminal discovery have a right to all evidence that the government has against you. You have a right to exculpatory evidence, which is evidence that suggests your innocence, or evidence that undermines that could be used to impeach a government witness. And you have a right to discover certain kinds of evidence that's being used in court by the police. But you don't have a right to all evidence that the government has against you, at least not as a matter of constitutional law.
Professor, we've been talking about constitutional law and state laws. We're also in a new executive. We have a new president. What could President Biden do that would make a difference in terms of regulating the police?
A lot of regulating the police is a subject for legislation, but there are things that Biden can do, even if political gridlock continues and there's no new legislation federally on policing. One example that he's already signaled he intends to do is more aggressively enforce federal civil rights laws. And that includes both prosecuting more police officers and turning the lights back on, and a program that President Trump shut down, which was civil lawsuits against police departments that engage in a pattern of practice of constitutional violations in order to reform those departments. So that's clearly something the Biden administration is going to do. I think they could do more as well.
In what regard?
Well, so for example, right now, federal law enforcement agencies are not a model of accountability and transparency for local law enforcement. Local law enforcement agencies, they're very variable, but some of them are out there in front on this, trying to work with their communities to make sure that they're transparent about their activities, that they publish use of force reports, that they talk about stops and the demographics of those stops, that all the policies are online, that disciplinary procedures are transparent and accessible, complaint mechanisms are easy to access. None of that is true of most federal law enforcement agencies. And that's something that Biden could help fix tomorrow with an executive order. I mean, I think federal law enforcement agencies, we're talking DEA, FBI, the U.S. Marshal Service, the ICE, all of these agencies should be models of accountability and transparency, not laggards. And that's not true today. One area I suggested is that they could make federal law enforcement a model, but another is that a lot of federal programs now actually incentivize a kind of harmful policing, that there's an inconsistent message being given out by the federal government. On one hand, we enforce civil rights statutes, but on the other hand, we encourage asset forfeiture and give out military equipment to local police departments without a lot of scrutiny of what they're being used for. And so I think, the other thing that the Biden administration could do is start providing a coherent vision of fair and effective and minimally harmful policing, and make sure that federal programs are consistent in pursuing that approach.
Professor, before we let you go, I've been referencing it on and off. You have a new book on police law. Do you have one handy?
I do, actually. I just got it the other day, and I'm really excited about it. I've been working on it for a bunch of years. It's mainly a tool for students, but actually it's really intended as a resource also for lawyers or journalists or activists who want to understand better how we currently regulate the police and how we might do so differently.
Well, Professor Harmon, thank you for taking the time to join us today on this important topic. And as this issue is clearly not going away, perhaps we'll have you back for follow-up in the future.
It's been a pleasure. It's something I'm obsessed with and have been for a long time, and I'm always happy to talk about it.
And thank you for watching Talks on Law.